So, good evening, everyone. So we were waiting for a few more participants, but nobody showed up. So we decided to start. And microphones have been deactivated. So if you need to ask anything, you can use the chat. And at the end of the webinar, we're going to answer all the questions. So yeah, you can use the chat for any request or information you may need. So basically, tonight's webinar will be held by me. My name is Giulio Palmerio. I'm a lawyer, and I'm part of the association. And I'm here with my colleague, Antonella Giuntoli, which held the previous webinar 2 days ago on Tuesday. And so basically, we're going to talk about the same institutions and the same principles that we already spoke about 2 days ago. It was held in Italian. Tonight it's going to be in English, but so it's going to explain the same stuff in a different language in order to be inclusive with everyone. So tonight's presentation is going to be synthetic, and it's going to be something not too specific because it's the first one. We will have many more chances and opportunities to talk about everything and explain and answer more questions. But so if you have anything to ask, you can use the chat, and at the end of the webinar, we will talk about it and we will explain everything that will be asked. So what we decided to do is to talk about the main principles and the main institutions of the maritime sector, the maritime industry. And we want to do it in a synthetic way, and we want to start from a practical case that we had to deal with, and we are actually still dealing with it because it's going to be the best way to explain both theoretical institutions and principles and practical aspects. So what we can start with is by saying that contracts are obviously fundamental, essential in a working relationship, especially in this sector, in this industry. And even though the Italian law is not precise on every kind of contract, I mean, not every contract needs to be signed with a written form. There are some exceptions. Provided by the law, for which some contracts have to be signed in a written form, and if they're not done so, they are invalid. And our sector, so the maritime industry, is one of them. So every contract needs to be signed in a written way, in a written form, and needs to be registered. And the registration is made with the transmission of the contract to the authorities, to the consular authorities. So it's essential and it's very important that after a contract is signed in a written form, it has to be transferred to the consular authorities. And the validity of the contract itself depends on it. And obviously what we're going to talk about today is referred to the Italian laws, because obviously the main aspect and the main focus of it will be the Italian space, and the different laws and legislations, the English one and the common law may differ obviously from the Italian one, but the core principles and the core institutions are basically derived from it. So what we're going to talk about may be different in other foreign environments and legal systems, but there are still some common principles that can be used and exploited. So we were talking about the written form for the contract, and the first basic principles and the first basic information and details that every contract needs to have are information and details and data about the ship owner, which are essential, about the worker, so the seafarer, and about the boat. Okay, so everyone needs to make sure that every contract contains this information that cannot be missed out. A common mistake that we see is that contracts are sometimes, actually often, signed without the indication and the specification of the flag of the nationality of the boat, which is a pretty bad mistake, because that implies that if a contract doesn't prove and specifies which flag and which nationality a boat is registered with, we cannot know which is the legislation and so the laws that are applicable and applicable to the contract. So that's a very important information. That's a very important detail that cannot be missed. When the flag is not indicated, at least there should be in the contract something that shows and demonstrates and allows to understand and to figure out what the legislation is. So the legislation that is referred to the boat and to every aspect, to every working relationship that is made and formed with the boat. So we are now going to talk about the length, so the duration of the contract. Obviously, referring to the Italian legislation, as we spoke about before, the contract may be signed and concluded in 3 different duration forms, which are basically a permanent contract, a fixed-term contract, or a contract that is signed for a single embarkation, so for a single action. And if the contract does not specify and does not specifically tell what the duration, the length of it will be, we have to presume the system, the legal system, the Italian one presumes that the duration will be permanent. So if it's not otherwise specified, it's going to be a permanent contract. Talking about the wages, so the salary of the worker, we have to talk about what's called the basically collective bargaining agreement, which is something that in this specific sector, the maritime industry, is even more important than the law, because unlike civil contracts, what really basically represents the foundation of these working contracts on boats is these agreements. The agreements are made by associations that are basically trade unions and trade associations representing different parts of the contract, so different sides of what's the working business, basically. So the worker and the ship owner or the employer, so employer and employee. And these agreements are what's actually the foundation, and they represent what the contract is based on. So the contract obviously cannot go against the specifications and what's provided by these agreements, unless it basically foresees and unless there's a better specification. So unless the contracts provides better conditions for the worker, it cannot go against what's said and written in these collective bargaining agreements. Obviously, this is relating to the Italian legislation, which may be different in foreign environments and foreign legal systems. But something that everyone needs to be aware of is that when we talk about the salary, so the wage, which is a very important aspect of the work, is that everything that is perceived and everything that the worker is paid for has to be considered as gross and not net, which may be ignored. And if it's ignored, it's a big mistake, because there's a big difference. So every aspect concerning, for example, contributes for pension, for retirement, or for obviously the tax, has to be paid separately by the worker. And that means that what he receives as a payment, as a salary, is basically not what he actually earns. So there's a big difference, and that's something everyone needs to be aware of in order to make the right decision when they get hired. And so in order to be able to know what's really going to bring them. Another thing that every contract should specify is the duties and basically the job roles of every worker. So the Italian legislation and the Italian contracts are generally more specific. They are less synthetic, and they are more basically providing information and details in a bigger way, in a wider and more complete way than, for example, English contracts. So job roles and duties and levels also are explained and listed in a clearer and more specific way, which may not happen in foreign contracts. So that's something everyone needs to be aware of, and that's something everyone needs to be, everyone needs to know that the Italian legislation offers this protection, and they may want to claim it even if the contract is made by a foreign legal authorities. Another thing that's very important is that every contract indicates and specifies what the email address of the boat of the captain is, because every formal claim, every formal communication that the worker may want to basically transfer and may want to communicate with the ship, so basically with the employer, has to be done with through this email that has to be registered in the contract, and that's basically the official means of communication with the ship. So every claim, everything, every request needs to be done properly and formally, and the email address is absolutely essential, and sometimes is forgotten. So that's a mistake that can be very problematic. And another thing that's often forgotten, and that's very important, is the Siemens book, which is basically like a passport of the worker, of the sea worker, of the seafarer, which tells the history of his personal and working history, and the history of the boat and the boats he's worked on in the past, which is absolutely essential and needs to basically register every variation of these mentions and employers. So that's something we unfortunately see often that's forgotten, and it's something we recommend not to be forgotten because it's absolutely crucial in the basically in the proper and right formal application for any job. So another thing that often gets asked, and that's often source of some kind of problems, is the trial period, because the trial period may differ from the Italian legislation and the foreign legislations also. So, for example, usually the Italian legislation dictates is a shorter trial period, which is usually not superior to 60 days, whereas we see often that other legislations, other legal systems dictate a different one, which is often much longer, and that can actually cause a lot of troubles, doubts, and bad situation for any worker who's not actually aware of that. Someone who may see his trial much longer than the one he expected. Same thing goes for the work day, so the duration, the hourly duration of every work day, which by the Italian legislation is fixed, is dictated in 8 hours per day, whereas in other legal systems, it's not properly specified like in the Italian one, but it's actually not referred directly, but actually different legislations, they refer to the rest period of the day, which can be usually in the measure of 10 or 11 hours per day. So that means that everything in the 24 hours that's not actually dictated as a rest period can be used as work. And that's much different and much longer from the 8 hours that our legislation dictates. So something we really need to stress out and we get asked often is concerns the termination, so the end of the working employment, the end of the working relationship. And so that's what we call the disembarkment, which may happen in two different ways. And it's actually a translation of what happens in the civil working relationship, where you can be fired. So the employee can be fired by the employer, or the employee can decide to terminate to end his working relationship and his working contract. We have different consequences, obviously, whether the working contract ends with a termination decided by the employee or by the employer. And that's basically because the employer can start a disembarkation, and so basically he can terminate the working process and the working relationship only if there's a right cause. So basically only in case of a justification that allows him to terminate the working relationship. And that's basically, sometimes it's used as an excuse, because sometimes it's the justification that the captain or the ship owner uses to terminate a working relationship is that the worker doesn't go well along, doesn't relate, and doesn't behave in a good social way with the rest of the crew, with the rest of the workers on board. And that's very general. That's not specific at all. And it's something that is used usually to take advantage of this position. And basically, it's a violation of the rights of the worker, because everything is to be specified. Okay, so it's something that is used like an umbrella to use all the rights that the ship owner and the captain may have to terminate this working relationship that shouldn't be done. So the real reasons that justify a disembarkment, so a termination of the working relationship from the owner, from the captain, is basically listed and might be really urgent and serious motivations, justifications, like if the boat or the ship has to shut down, so it's not used anymore. That may be one of the reasons. Or extraordinary operations, like the boat has to be refitted, So in that case, obviously, the boat is not usable anymore, and that may present a justification for the end of the working relationship. If the boat is sold, or if actually the seafarer or the stewardess shows a behavior that's actually not well fit for working on a boat. But there are, as I said, very specific reasons that are often violated. On the other hand, if the worker wants to terminate his job, so his working relation and his working contract, he can do so. He doesn't have to basically explain, and there are no listed reasons for his termination as for the other side, for the employer, but there's a notice that has to be basically respected. So there's a notice that has to be, basically he has to let the other part of the contract know that he wants to end his working contract with a certain advice, which is called a notice, which is usually in the Italian legislations is fixed and it's dictated in 15 days, but obviously different legislations may present and may dictate a different term. So basically, we see often that what is dictated and what's mandatory for the employer in case of a discharge is that he needs to justify, he needs to write it down, and there has to be a proven document that allows the termination of the working relationship, and everything has to be written down. So again, we need a written form, just like for the contract. But too often, and that's something that we saw in the practical case we are dealing with now, these seafarers, a man and a woman, they were told to leave the ship, so their job was terminated without anything written. So they didn't receive any written discharge. They didn't receive anything. There was no specific indication or explanation for the reason the contract was over. So without receiving anything, they were just terminated. And still 2 or 3 weeks after that has happened, they haven't received anything. That's obviously something that's not correct, that has happened in the past, but that's something everyone needs to be aware of, because in case it happens, they need to know, everyone needs to know that they have the right to be paid until they worked and until the contract is over, and to be basically to receive the written documentation and the discharge that they, in many cases, that they haven't. And yeah, well, actually, we spoke and we talked about a lot of stuff in a generic way. So before we can open up for questions for the few people that are here, just something everyone needs to know is that all the information that everyone working on a boat receives has to be absolutely reserved. And this is called the confidentiality clause, which goes well beyond the termination and the end of the working contract and the working relation, which goes basically doesn't have a fixed term. So everything that everyone knows due to his working relation on a boat needs to be secret, even after the job and the contract is over. So if anyone now needs to ask anything, we are going to look at the chat. So if anyone wants to ask anything, we are here to try to help you and to explain any doubt you may have.
Hi, Giulio, sorry. I have a Maltese contract, and it's a bit tricky understand the hours, the working hours per day, because generally is just written just the amount of hours per week, and actually is so difficult to understand. For example, on board where I'm working, we work from Monday to Saturday, and generally on board the Italian boat, or generally with a gentleman agreement during the winter, the working week is from Monday to Saturday, and sometimes we feel a bit, how can I say, in the middle, say, okay, but I'm working during the summer like 16 hours, and it's not correct. But because it's not specified in the contract that the working week is from Monday to Saturday. But okay, no, you work on Saturday. But okay, if the captain says this, we have just to follow, or actually we could, I mean, propose something.
Okay, so yeah, this actually refers to what I tried to speak about generally before, that the Italian legislation and the Italian contracts are usually more precise and specific. So they are based on these general bargaining agreements, which are not present in the foreign legislation. And so, like, there are more direct, set of rules that actually dictate how much and how many hours each day and week a worker can perform. Whereas these foreign legislation, they are obviously not based on these general bargaining agreements, and they don't specify the amount of hours that have to be worked daily and weekly. So, as I said before, they do it in a reversed way. So they don't specify. They don't specify the amount of hours that have to be worked, but instead they dictate what the daily or weekly amount of hours of rest need to be taken. And that's a way actually to take advantage of that from the employer, because it's basically, if they say that it has to be 11 hours per week per day, of rest, that means that theoretically all the remaining hours are usable as work for the employer. And that's why I was saying, and we were stressing out the fact that every contract that's based on the Italian law and legislations and agreements are way more protective towards the workers, towards the employers, whereas generally the foreign legislation does exactly the opposite. And what you were saying is a perfect example of that. It's a demonstration of that.
Okay, thank you so much. So actually, because generally on board foreign flag is we have a gentleman agreement.
Yes.
I give you more time, more day off during the winter, and summer I ask you a lot. But generally, captains doesn't understand that during the winter we need to rest, we need to sleep enough to be ready for the next season. Sometimes this is not clear, but anyway, maybe something should be changed in the contract, in the, I mean, probably the Maritime Labor Convention could be create a contract not for ship, but a specific contract for yacht.
Yes.
That's probably is the problem because we have a unique standard contract and actually it's not that
Yeah,
contract doesn't fit for our
it's not the right fit for your specific situation. Yeah, that's what I was thinking about.
Yeah.
I mean, everything it's a general principle that the more specific a contract or an agreement is, the less space for exploitation there is. So basically, if the contract foresees and predicts a series of cases and hypotheses, the more specific it is, the more you know what your rights and the counterpart's rights are. So I mean that's a general advice to try and specify everything, and I mean leave the least space you can to abstraction in general areas, because that's where the strongest party in a contract or in an agreement can really take advantage of your position.
Thank you so much.
Thank you. Chat. So we were looking at the chat. We saw there is no more. I mean, there's actually no questions. So obviously, if you want to ask, just let us know. So I guess the questions are over. And if it's so, we can end this meeting, this webinar, and we look forward to the next one. I guess there will be another one soon with more people, hopefully. And yeah, and obviously subscriptions will be open soon. So I guess maybe there will be a chance for a personal meeting, like a physical one. But I'm sure everything will be advised and advertised properly and on time.
Thank you so much, Giulio. Thank you for the girls that came tonight. We are not so lot, but actually, if the other girls needs the record, no problem. We will send in a few
Everything
days.
has been recorded, so
And
it's still
yes,
recording now, so it will
exactly.
be available for anyone who's interested.
And if you have some extra question, please feel free to contact us on info at assystew.com, or you can contact us through our website, assystew.com. Okay, thank you so much, everybody.
Thank you,
And
everyone.
see you
Thanks,
to the
everyone.
next
Have a good
webinar.
night.
Good night. Bye.
Bye.